In class 15, which wound up being truncated a little by some connectivity problems, we spent the entire time discussing Chevron. As I've said, Chevron is the most cited case in American law. It's certainly the most important case in this course. We're going to spend multiple classes working through its framework. And that's a framework for evaluating when an agency has interpreted a statute, how a court should see that. So in this case, we had the EPA, which put out a regulation that had changed how it was defining a stationary source of air pollution for purposes of the Clean Air Act. And the Natural Resources Defense Council challenged that rule, saying it was inconsistent with the statute. The Court of Appeals did what we had come to expect courts to do after the pre-Chevron cases like NLRB versus Hearst and so on, interpret the statute by looking at its text, looking at its legislative history, looking at its purpose, and so forth. The Supreme Court, though, framed the question very differently. It didn't frame it as what is the correct definition of stationary source, but as whether the EPA's interpretation was based on a reasonable construction of the statutory term stationary source. And so the court had explicitly framed it not as we're going to solve the answer, we're going to come up with an answer, but as a reasonableness inquiry where there might be multiple answers. And that's a critical shift here. So to answer that reasonableness question, the court announces this two-step analysis, where step one is, the question is, and I'm quoting from the opinion here, whether Congress has directly spoken to the precise question at issue. And so if Congress's intent is clear on the question, that's the end of the matter. For the court, as well as the agency, must give effect to the unambiguously expressed intent of Congress. So if Congress has already answered this question in the statute itself, like if the definition of stationary source was clear that either it encompassed this bubble concept or it didn't, that would be the end of it. And then the court says on step two, if, however, the court determines that Congress has not done that, has not directly addressed the precise question at issue, then the court doesn't simply construe the statute as it would in an ordinary case where there was no agency involved. Rather, if the statute is silent or ambiguous with respect to that specific issue, the question for the court is whether the agency's answer is based on a permissible construction of the statute. And this has become the standard two-step Chevron analysis. So this raises a bunch of interesting questions. First, how is this at all compatible with the Administrative Procedure Act? Because it says in Section 706 that the court must interpret questions of law. Well, in Chevron, the Supreme Court says that when the statute is silent on something, that is an express delegation of authority to the agency to elucidate the specific provision of the statute by regulation. We might be skeptical of that because when Congress wants to make an express delegation, it knows how to do so explicitly, not implicitly. So, for instance, there are lots of statutes that direct an agency to adopt regulations interpreting some provision, like the Affordable Care Act. Essential healthcare benefits are something that are left to the agency to interpret. And so if Congress knows how to do this explicitly, it's a little odd to think that they're also intentionally doing this by simply being silent. Second question, if this is not something that is explicitly required according to the statute, are there other reasons we might think we should embrace this rule anyway? And so there are a bunch of them, and we discussed some of these in class, and some of them are additional points, but there are some reasons beyond just this implicit delegation idea that we might agree with Chevron. So as a statutory matter, maybe it's just this default background rule against which Congress can legislate. And that's going to be useful for predictability, for forcing Congress to express its preference if it wants to do something different. So this was Justice Scalia's view before he was on the court in a paper called Judicial Deference to Administrative Interpretations of Law, where he said, if we have an ambiguity in a statute, there are two possible ways to get that. Congress intended a particular result but wasn't clear about it, or Congress had no particular intent on the subject, but meant to leave it to the agency. And Justice Scalia says that if we go through the history of cases before Chevron, the court sort of chose between these two possibilities on a case-by-case basis, which was very hard to predict outcomes, led to a lot of inconsistency and so forth. But if Chevron replaced this with an across-the-board presumption, then Congress can avoid that if it wants to in a particular statute. And if not, then at least we know what the court is going to do. And so maybe there's a good case for a default rule here. As a policy matter, maybe this is a good rule because it uses the expertise of the agencies. And so if we have an ambiguous statute, who would be better equipped to decide the better version? The courts or the expert agency? Probably the expert agency. We don't have that benefit in ordinary cases where there is no agency. And so in that case, maybe looking at what courts do when there is no agency is a bad comparison. And so as an institutional design matter, in a normal case, if you have an ambiguous statute, courts have to construe it because otherwise you can't decide the case. But here we have a better choice. We might as well make use of it. And then finally, as a separation of powers matter, maybe Chevron is a good rule because it limits the power of courts, which otherwise lack political accountability. The political branches probably were not going to elect a president or not based on like the EPA's interpretation of the Clean Air Act. But if we have a president who campaigns on a deregulatory agenda and appoints officers of agencies who are committed to carrying out that agenda, that might reflect the will of the people and what they've wanted. And so as a separation of powers matter, maybe it's a better approach because it is going to limit the power of courts to make up interpretations that are not necessarily accountable to the people. And so in Chevron itself, step one played out with the court looking to these four traditional tools of statutory interpretation: the text, the legislative history or the legislative intent, the purpose and structure of the statute, and then canons of construction. And here, the text does not especially help because it doesn't tell us what Congress thought of individual physical units within a larger plant complex. It seems like Congress didn't really recognize that that was an option. And if we look at the legislative history and the purpose of the statute, those are similarly not helpful. No canons seem to be particularly helpful. And so the court moves to Chevron step two. And under step two, the EPA's interpretation of the law seems reasonable. It seems designed to further one of the statute's explicit purposes, which was making it economical for plants to operate, even if it means that another of the statute's purposes, the environmental purpose, might have some counter effects, right? And so it seems like a reasonable balance of different concerns. As we're going to see in our subsequent cases, over time, the court has become more and more probing in step one, finding more statutes unambiguous, even though we might identify ambiguities in them. And so we're going to spend a few classes on how courts have applied these different steps of the Chevron framework. And so I will see you for those.